We are out live on YouTube as well.
Okay, great. We're still waiting for a few minutes for people to join. Maybe we'll start by 2 minutes past 6. Okay, it's 6, but I see that people are still trickling in. So 2 minutes past 6, we'll start. Okay, let's start. I think there's a pretty good attendance today, which is great to see. Thanks so much, everybody, for joining. This is a kind of a public call that we put out. So I hope that all of you already know what IFF is. If you don't, we are the Internet Freedom Foundation. We are a digital liberties group organization that's based out of New Delhi, although our work is more or less pan-India. We've been involved in work surrounding free expression, privacy, surveillance, intermediary liability, etc., and safeguarding your digital and constitutional freedoms online since 2016, 18 or so. We're entirely community funded and community driven. And so we rely on you good folk to keep donating to us. And thanks for the ones who already do. I am Tanmay. I'm the Senior Litigation Counsel at IFF. For this call today, I'm joined by my colleagues, Abhinav, who is an off counsel at IFF. Abhinav Sekhri has about 10 years or so experience in criminal law and constitutional law, including in issues relating to free expression, which is going to be pretty much the prime focus of today. I'm also joined by Gayatri Malhotra, who is an associate litigation counsel at IFF. And we are all Very happy to see you guys. Now, I planned to start by giving you a quick brief overview of Section 69A and the 2009 blocking rules. And the thing is, all three of us are lawyers, by the way. So this is going to be a slightly legal analysis of a judgment. You don't have to have read the judgment before talking to us, because it is 110 pages. And I would admit, I have also not read like the entire thing. I've read the important parts that Abhinav has told me. Abhinav has read the entire thing. Right, Abhinav?
Yeah.
Okay, great. Fantastic. Good. Thanks for that, Abhinav. Very confidence inducing. But in our research, Gayatri seems to have found a very interesting tidbit from history. So I'm actually going to let Gayatri take over for the next bit. Gayatri, do you want to share that with everyone? Gayatri.
So it seems that Gayatri is actually experiencing some technical difficulties right now. So Tanmay, do you mind taking over for a few more minutes while she tries to get back on the call?
Yeah, sure. Fantastic. Why not? Now, my expertise on this particular matter is not as deep as Gayatri's, but I will try what I can. Shala, will you change the slide?
Gayatri's here.
Yeah. Okay. So we managed to find, Gayatri managed to find like perhaps the first ever blocking order issued in India in 2003. Now, this well precedes Section 69A of the IT Act, under which blocking currently happens, and also the 2009 blocking rules, which lays out the procedure for blocking. And if you see here, this is very different from the sort of thing that you get to see these days. I mean, if you ever are lucky enough to see a blocking order from the government. But this is clearly a very different procedure from what you get to see under the Section 69A and 2009 blocking rules. Now, Section 69A of the IT Act was inserted in 2009, which basically says that where the central government, so remember that this power is not existing with the state governments, it's the central government only, which when it is satisfied that it is necessary or expedient to do so, in the interest of sovereignty and integrity of India, defense of India, security of the state, friendly relations with foreign states, or public order, or for preventing incitement to the commission of any cognizable offense relating to the above. It may subject to the provisions of subsection 2 for reasons to be recorded in writing by order, direct any agency of the government or intermediary to block for access by the public any information generated, transmitted, received, or stored or hosted. Now, what's important here, in addition to the central government part, is that there are 6 enumerated reasons under which blocking can happen. I'll say those again. It's in the interest of sovereignty and integrity of India, defense of India, security of the state, friendly relations with foreign states, public order, or preventing incitement to the commission of any cognizable offense. What we have seen, and we've been involved in some litigation surrounding censorship on the internet, including on Twitter, in the Delhi High Court and in the Bombay High Court, where matters are ongoing. What we've seen is that we are very fortunate, by the way, and Abhinav had argued that matter that day in court in Tanvir Thakur versus the Union of India, where Justice Manmohan of the Delhi High Court had ordered MIT, the IT ministry, to actually disclose the blocking order to Tanvir Thakur, who was the petitioner in that case. His website had been blocked by order of the IT ministry. And it was rare to see the blocking order. We'd seen it. And what we'd found was that it followed a bit of a checkbox approach, where there was a table which had these 6 reasons set out as columns, and the ones that MIT felt were attracted were just checked as a yes. I'm not 100% certain if that is the intention of the act, particularly in the place where it says for reasons to be recorded in writing, but we'll get into that. Abhinav, do you want to jump in and talk more about how the power under Section 69A works and how that has been discussed in this judgment?
Yeah. So, hi, everyone. I actually wanted to take a little side note first and just talk a little bit more about what's on everyone's screen right now, which is this blocking order. So just a fun fact, and anyone who wants to look this up just needs to search for the name of the group in question. This actually relates to a small part of history where what happened was that there was actually a full ban on Yahoo groups. And I think a certain section of the population will remember Yahoo groups. A certain section will be like, what was Yahoo groups? What are these things? but I belong to the former category. And because of Yahoo's decision to not comply with this particular order, the result was a takedown of the entire service called Yahoo Groups across all ISPs. And if you go through the coverage at that point of time, it's actually full of mirth at the failed or sort of botched attempts to do this exercise of website blocking and regulation. And sort of you is a good seg to talk about 69A and how this particular instance of blocking seems to be rather meek, and it's like a babe in the woods kind of thing where we didn't really know what we were getting out into, whereas today blocking of content in India is a really muscular exercise, which and the legal basis for that muscular exercise is section 69A of the IT Act and the corresponding rules that were enacted. Let's just call them the blocking rules for now. They have a really long-winded name. So as far as this judgment is concerned, and do we want to just put up the slide that if Gayatri is available, do we want to just put up the slide that summarizes exactly what were the issues, Gayatri, before we do our sort of dive into the issues?
Yeah, glad to see that Gayatri is back. Gayatri, do you want to just take us through the arguments that Twitter had made in this petition and the counters to those arguments that the government had come up with, and then we'll get into what the court actually held.
So, hey everyone, I'm back. Here's a quick summary of the arguments that Twitter made before the Karnataka High Court. So, just for a little bit of context, Twitter filed a writ petition before the Karnataka High Court seeking challenging certain blocking orders that took down specific tweets and whole accounts. Most of these tweets and account blockings took place during the context of the farmers' protests. Uh, so, the blocking orders comprised of over 1,400 Twitter accounts and 175 tweets, out of which Twitter challenged a total of 39 URLs. Very briefly, Twitter challenged the blocking orders issued by Mighty on the following grounds. Firstly, Twitter argued that under Section 69A of the IT Act, the central government can only direct intermediaries to block specific pieces of information, and it primarily relied on the tense used in this position to indicate that since as past tense being used in the position, they could only block information which is already in existence, and they could not block information which is yet to be produced. However, the central government responded to that by saying that the word information in section 69A is quite wide, and since the URL of an account can be identified, the wholesale account blocking is also permitted under section 69A of the IT Act. Next, Twitter argued that as per Shreya Singhal, which upheld the constitutional validity of section 69A and the blocking rules, originators as well as intermediaries must be given a notice of blocking under the act and the rules. However, the central government argued that Rule 8 of the blocking rules can only be availed by citizens, and Twitter cannot claim to espouse the cause of Twitter users. Uh, Next, the government countered Twitter's point by saying that they were not in possession of the details of the originators, and Twitter was in possession of these details. And when Twitter was offered a hearing under the blocking rules, at no point in time during those hearings did Twitter offer the details of the originators to the central government, nor did Twitter make the case that no notice was issued to the originators. Next, the blocking orders must be a reasoned order, and such an order must be communicated to the intermediary. Twitter also contended that it did not have the opportunity. It did not have the opportunity to avail a proper hearing, which violated the principles of natural justice. Lastly, Twitter argued that the wholesale blocking of accounts was a disproportionate measure under Article 14, 19, and 21 of the Indian Constitution, to which the central government responded that since Twitter is a foreign company and not a citizen, it cannot claim protection under Article 19 or 21. As for protection under Article 19, one must be a citizen, and for protection under Article 21, one must be a natural person. Next slide, please.
Yeah, I think that's quite a helpful summary of what Twitter had argued and what was the argument that they received in response from the government. Abhinav, just come in for a second and talk about the question I'd asked you earlier about how the power under Section 69A actually works and how that's been discussed in this judgment. But just one thing for all of us to keep in mind is that it was Twitter who approached the court. And so the judgment is very heavily viewing this whole issue from the lens of how it affects the intermediaries. And because of that's how the judgment is, we will be focusing on intermediaries. Although we'll try as much as we can to try and speak from the user's perspective, because that's what you guys all are, I presume.
So, and it's interesting that Tanmay mentions that, because what the judgment doesn't mention is how, while it goes hard about the fact that Twitter is an intermediary and there are no users, interesting tidbit, there were certain intervention applications or petitions that got filed, but they were dismissed during the pendency of this matter. And that for good reasons or bad, and it's not that those interventions came to be challenged by those specific petitioners. But just to set the record straight, because it's not mentioned in the judgment, there were attempts by people who were directly aggrieved by this, by the overall question. So they might not have been the people who Gayatri mentioned would have been in the list of URLs that Twitter had gone after, but people did go to court. So I just wanted to flag that for everyone. So that's one. In terms of the power under 69A, so let's just now, I want to break this into three things, right? So first of all, we're not talking about the process, but the process itself of how the rules operate, notice to users, etc. We'll come to that in a bit. But the first part of this is the clause itself, right? So what is the power? How does it work? What is the scope and coverage of it? And most importantly, at least from this perspective, what is the scope of review by courts when they are faced with questions about the improper exercise of this power? So let's look at these three questions in turn, right? So on coverage, Gayatri just informed us that the argument, and one of the critical arguments was about, is it about a tweet, a specific tweet? Can it extend to an entire account? Or funnily enough, or not funnily enough, what about hashtags? And can hashtags be the subject of blockings themselves? And then on the content of 69A, we see, and I noticed some members of this call are people who have written about this issue as well. Yes, I'm talking to Karthik, who I know has entered the the call. There is an interesting sort of subterranean level at which the judgment is operating, where it seems to privilege, the reasons that are there, and especially the reasons for the interests of state. So on these two, the rather sad but not so sad take that I would offer is that it's not really as bad as we might think, because hey, it was actually really bad already, right? So I don't know if that is sounding reassuring to anyone on this call. It definitely is to a lawyer, because ultimately you're not dealing with something that is setting back jurisprudence by some eons or something like that. It is actually developing a line of thought that does definitely exist within our existing framework, and so therefore the ways to deal with it are also already there, right? So that's the first thing, where, for instance, on the issue of having forward-looking coverage as far as the power to censor content is concerned, it's actually an issue that the Supreme Court had considered and dealt with as far back as 1957 in the context of newspapers and censoring newspaper content for extended periods of time. And similarly, when you look at the ideas of the content of 69A itself, it is mirroring, for better or for worse, the broad categories that are in place within the Constitution. And laws repeating just these broad categories is a legislative practice, again, that the Supreme Court has upheld actually since 1950, and literally the year that the Constitution came into force. What makes the Twitter judgment interesting and problematic at the same time is how the court deals with the issue of judicial review of this entire exercise of power. Here is where I would want to put forward a view that what is important is not only what has been said by the court, but also what is left unsaid. Where, for instance, and where the court is saying things, it is fortunately or unfortunately contradicting itself in certain parts. So, for instance, as Gayatri mentioned to us, it does mention that reasons are important, whereas at a later point of time, it mentions that the reasons are important, but they may not be part of the same part of the order itself that is being questioned, but they may be found elsewhere. And so you're left wondering as to when do you decide this is the case? Similarly, the judgment tells us that, the logic of proportionality is inherent to constitutional adjudication. But since Twitter is a foreign entity and cannot claim citizens' rights under Article 19, I don't necessarily need to apply proportionality. However, at the same time, the court actually does apply some sort of proportionality analysis, where the court looks into things such as blocking itself has some sort of legitimate purpose in the specific instances that were identified for the court. And at least in the eyes of the court, and this is where ultimately, the rubber hits the road, the exercise of power was found all right. And ultimately, given that this exercise of power is by an executive authority, there is a level of deference that a judicial forum must accord to the executive in such matters. So there is a certain distance that a court will travel, but it will not second guess the decision that has been made by an executive. Again, this is not new by any stretch of imagination, but this is really administrative law 101, where any judicial exercise of power is not going to, reinvent the wheel when it is acting in supervisory jurisdiction. The problems are about how the court continues these lines of thought, but doesn't really develop them with how the law has developed. Pardon me. So, for instance, when we speak about proportionality, and again, I'm sorry about the jargon here, but proportionality as an idea is basically speaking to a very simple concept that if the law is allowing for reasonable restrictions, proportionate restrictions are, in a sense, the essence of reasonableness. And the law tests whether or not a measure is proportionate as a means to determine whether the restriction in question is reasonable. I hope that was a simple enough summary of the logic of proportionality. But where the court doesn't offer the kind of assistance that one would be really benefited from when you're dealing with a constitutional court is offering a metric of some sort of analysis as to how future courts can go ahead and do this exercise of judicial review. So where the court tells us that, yes, you can ban an entire Twitter handle in exceptional circumstances, it doesn't help us by outlining to whatever extent possible what such exceptional circumstances might be. Similarly, when the court goes ahead and tells us that it is possible to ban a hashtag for a certain period of time because of the kind of harm it might entail, it doesn't tell us exactly what kinds of situations it has in mind. Unfortunately, at times it does feel that in this particular case, the reasons might have been obvious to the court. And so you can say that it was not required for the court to deal with anything beyond the specific case it had. But given that these are questions that are so relevant to the regulation of content blocking, any sort of guidance would have been extremely beneficial to achieve a manner of objectivity or at least fairness in how the powers are exercised. So in terms of the powers of blocking itself, Tanmay, I think that's the large point that I would want to flag, where what the judgment hasn't done actually leaves scope open for future courts to at least try and do this. So if you have a regime that allows for extreme measures such as blocking an entire Twitter handle, then it is still open for courts across the country as well as the Supreme Court to try and come up with some sort of criteria as to what are the extreme and exceptional circumstances in which these powers may be exercised. And it's not something that needs to be emulated in terms of what the Karnataka High Court has done, which is to adopt broadly what can be summarized as an "I know it when I see it" approach, in terms of, oh, it was so bad because the moment I read it, it felt to me that this was an appropriate exercise of power. I think then we can maybe move on to the issues of the process.
Yeah, dude. Sorry for calling you dude, but but basically that's what I really want us to focus on is that I know that you've read the judgment a bunch of times, and you called me and you said, oh, there's a lot of things that they don't discuss, which means that it's open to future clarifications, and there are ways out of this. I mean, it's not really none of us should be under the impression that this is not a pro-censorship kind of a judgment. Let's not say pro-censorship, but like it's a judgment that will increase and encourage censorship in the future. But there is a message of hope, right? Like there is a way that we can see out of this.
So let's be very clear about one thing, right?
Yeah.
And I don't want to leave any illusions because this is creating a permanent record of sorts.
Yeah.
Any regime that works, and I'm not talking about India here, I'm talking about legal regimes. This is a way in which states operate today. They delegate power to the executive government officials to make certain decisions. And this entire framework assumes certain things, right? That those decisions are going to be reasonable, they're going to be reasoned, they're going to be made by people who have certain levels of expertise in making those decisions.
Yeah.
It is these features of this kind of decision making which accords it some sort of sanctity for a court then to give it some deference.
Exactly.
So that deference, what happens, however, is that deference ends up being unsaid. So the problem is in any system like this, where the power to do the blocking is delegated to the government, a court it's being exercised by, as the Karnataka High Court keeps telling us, high officials in the government, high ranking officials in the government.
Yeah.
There is a sense of deference that courts historically have always accorded to decisions by high ranking officers. But that deference is on the basis of certain assumptions holding true, which is a reasonable decision, a reasoned decision, and that there is a level of expertise, right?
Exactly.
What still is open in terms of argument, etc., for the future is definitely engaging further on these assumptions for all future cases. There is no question that there is a certain measure of deference. But however, that does not stop a court from questioning these fundamental assumptions in each case of blocking. Especially, and as in fact, courts across the world have held this, when it comes to matters of fundamental rights, which is where this logic of deference inverts. While in matters of administration, you will assume that a government might know better than a court. So a government may know better about matters of policy. But when it comes to matters of determining the scope and extent of fundamental rights, it can't be said that the government knows better than the court.
Correct.
And so especially in matters of fundamental rights, where there is a lot of scope for continuing the argument, so to speak, is to re-agitate this fact that deference is not something that bars or in any manner forecloses the opportunity for a court to ask tough questions. Because ultimately it is the court that is the custodian of constitutional rights and the interpretation of constitutional rights.
Yeah. So, okay. So then take us through it. Take us through the procedure, because I mean, procedure is really where it's at, where it actually, the conceptual power under 69A, where it actually plays out.
Yeah, absolutely. I mean, you're preaching to the choir where criminal procedure matters a lot more than criminal substance, unlike what law students might think and like what a lot of true crime might teach us. It really is a lot about procedure. I think this is really the most controversial, one of the most controversial parts of the judgment, and one of the biggest contradictions at the heart of the judgment sort of comes out when we deal with these procedural aspects that the court has sort of considered. And let me flag these in whatever little systematic effort that I can try and muster. the core issue here is twofold, right? That I would want to identify. And all of this is happening obviously in the shadow of the kind of content that the court was asked to rule on, which, as the slides above are showing us, content that was being portrayed as being treacherous and quote unquote anti-national, a category that remains elusive in its definition, something that I've actually commented upon a lot earlier, but remains nevertheless difficult to erase from judicial and governmental records. Be that as it may, the idea here was the court is influenced by the seriousness of possible flaming of passions, so as to justify possible cutting of corners in what it identifies to be the rules process. However, what the court doesn't fully accept, even though it does identify this, is that the rules themselves have what is an emergency power within them. So there are two kinds of blockings that can happen. One is by an emergency power, whereas you block first, ask questions later. And the second is the step-by-step approach, where you first determine and then decide whether or not blocking has to happen, which assumes a level of hearing has taken place. What the court seems to, because again, a lot is left unclear, suggest is that, the seriousness of the kind of content justifies anticipatory blocking more often than not under the normal process. So doing away with the right of hearing, doing away or at least curtailing the right of hearing because of how serious the content in question is in terms of its potential harmful effects on society. But that's the problem, right? You don't need to cut corners because the rules already have a quote unquote cut corner process in place. So you can just rely on that. The court doesn't really answer this question, which then brings you to the kind of corner cutting that the court endorses, which for me is really problematic, which is the court seems to suggest that depending on the kind of content, it might be good in some cases not to have people come up and be given a right of hearing. So, Gayatri, you may want to find those specific sections in the judgment where the court suggests that given the kind of content that was at play, it was actually better that the users were not called in for a hearing because they might have used this opportunity to pursue illegitimate aims. So yeah, so that's the part. It is plausibly explained as to why no notice was issued, because the idea was to try and jeopardize national security. So it's basically a house of cards, right? So it is a set of assumptions that the decision is based on. And the hearing process is designed to question those assumptions by allowing the user a foot in the door and a seat at the table. But you already prejudge the entire situation by alluding certain motives to that particular user and justify the fact of not giving that person a right of hearing. So this is something that is completely not endorsed within the rules. And if this is a fear that the court had, again, the rightful recourse was to invoke Rule 9 and not do this to what is the actual way in which blockings are supposed to happen normally. And this is where the judgment, according to me at least, seems to stray afoul of what was held in Shreya Singhal's case, which is a good seg to now move into that other part about giving an option of who must you call for a hearing. So Shreya Singhal clearly does say that where the user is identifiable, you must give an opportunity of hearing to a user. It does not caveat this with an idea such as, oh, if you think that giving the user an opportunity of hearing is going to cause certain effects, don't give them this option. There is no such caveat, either in the judgment or in the rules. Similarly, Shreya Singhal does admittedly say and the rules say give an opportunity of hearing to the intermediary or user. Shreya Singhal elevates this to create a requirement where the user is identifiable to then necessarily call the user. But a question that is left unanswered in Shreya Singhal and actually left relatively unanswered even in Twitter Inc., or rather X Corp, as the judgment may be called, is on whom does the burden lie to identify this unidentified or identifiable user? So we've all used Twitter enough to know that a lot of content on Twitter is by bots and unidentifiable persons. So how do you really go and conduct the exercise of identifying this user, right? In some cases, yes, it is a verified account and so on and so forth. But then in some cases, it's not. And ultimately, it is a real question to how would you implement this. The judgment at some parts indicates, it gives you hints as to what is currently in place, which is that ultimately Twitter is the one who is helping the government, as it has to figure out who is the user in question. And then ultimately, from our practical experience also, we can vouch for this. In some cases, it is the intermediary that informs the user about the blocking of content, and then informs the user about their legal remedies in terms of writing to the ministry and the concerned committee. But that none of that is clearly set out, and the judgment itself also sort of flip-flops on this proposition as to on whom is the burden. Is it upon the government, or is it upon Twitter, or is it some sort of a collaborative exercise that these guys are undertaking? So lastly, and for me, really the heart of the problem in the judgment that remains unanswered, and this is a conversation that I've had with a lot of people. If you take a look and take a step back from the judgment, especially on these issues of notice, where it becomes really like startling, what the judgment and this entire exercise is suggesting is that there are definitely two categories of interests at play. There are the users and there are the intermediaries. The judgment again and again seems to suggest that an intermediary is in good stead, right? Where it's good enough if the intermediary is in the room and is voicing an opinion on the blocking of content. In fact, the government at several points of the judgment used the fact, the government at several points in the arguments used the fact that, look, we heard Twitter and we decided not to block 9 accounts out of the 11 accounts that we wanted to block. The judgment uses this to suggest that the presence of the intermediary is a good via media, right? So which is why, again, having the user or not having the user is something that can be swept under the carpet, so to speak. But if we take a moment and pause here and ask ourselves, is that really the case? Because the user and the intermediary are fundamentally at odds on a very, very core premise. Because an intermediary is by definition agnostic to whatever content is uploaded on the platform. An intermediary cannot be expected to harbor any position on whether something is good or bad, or whether something is legal or illegal. It is ultimately for the user to answer that question about exactly what are the bounds of my legal speech here. To expect and to justify a regime where Twitter is the one who is making these calls is placing forth a clear contradiction in terms of the entire heart of the concept of what it is to be an intermediary at one level. At another level, it actually poses a different set of problems, because we know that this is what is happening, right? Twitter is in the room. Twitter is the one who is entering into these conversations with the government, which then makes you wonder exactly what is the modus operandi of those conversations. So is Twitter more aggressively defending a certain class of persons and their content as opposed to others? So because Twitter ultimately does not need to defend all content equally. So we don't know exactly how is that interest of the user being represented, right? So all of that makes you wonder exactly how does this core premise, this core idea sort of go unnoticed throughout the judgment, that it can never be good enough for the intermediary to be in place of the user when we are having those conversations about whether or not content should remain online. Because the intermediary's only interest is to make sure that it remains on the right side of the law, to make sure that it has the protections of Section 79 of the IT Act, which protect all intermediaries from any liability.
Correct.
That is the only skin in the game the intermediary will have.
Yeah. So, okay. So I'm just gonna, so I want to keep about 20 or so minutes for questions and answers. And somebody's already mistakenly DM'd me a question, which was clearly not meant for me. Gayatri, I just want to quickly ask you, what do you think happens now? Like, if your laptop is now cooperating with us, which would be great because we do work in technology. What do you think? Where do you think we go from here? If you have any thoughts.
That's a really interesting question, especially for originators. Uh, as followers of IFF will be familiar with Rule 16 of the blocking rules. If an originator actually does identify themselves and approach Mighty approach Mighty, very often in RTI responses, they are denied a copy of the blocking order or any other information of the blocking process while citing the confidentiality requirement under Rule 16 of the blocking rules. And as you sort of started off the call with Tanul Thakur's story, that's almost been 2 rounds of litigation before a high court, and he still does not have a copy of his website blocking order. So it's going to be quite interesting to see how future courts interpret this judgment. And as Abhinav said, many things are still left unsaid. So I am still a bit hopeful that maybe things get better.
Oh, yeah. Well, optimism is always a good thing. Thanks, everybody. I think that's the panel part of it. We'll move to the question and answer part of it. But just want to say, if any of that was interesting or useful or helpful or at least fun for you, please do consider becoming a member or a donor at IFF. Every little bit obviously helps. And this is really what keeps us going. So thanks for joining. And Shaila, do you want to like stop screen sharing so that we can all go to a bit of a gallery format? And if this is being live streamed, then do we keep the live stream on or do we kill it, or what's the decision there?
Yeah, we are stopping the live stream.
You can just type it in the chat box.